State versus Ashley Clark, 22 CR 216. Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Here we go. The courtroom is quiet, the tension thick, but you can feel it building because our sovereign citizen thinks confidence alone can win the day. Every word they speak is dripping with bravado and self-assurance, while the officer sits calmly knowing this will go exactly as predicted. Meanwhile, we get to witness the classic clash between overconfidence and procedure. It's almost poetic, really, because nothing beats the drama of someone trying to outsmart a system that has rules and experience on its side. You can almost hear the gears turning in the officer's head as he calmly recounts facts while our self-proclaimed genius plans their next move. Meanwhile, the audience is left shaking their heads because every action here screams, "I can handle this," until suddenly reality begins creeping in. This is the moment where theater meets law, and we get front row seats to a train wreck in slow motion. The irony is delicious and the lessons unmissable.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay. State has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right. Ms. Clark, any opening statement?
No.
Now this is where it gets really fun, because the teaching moment begins. Our Karen has entered the realm where gurus and online videos are suddenly useless. The advice that sounded so clever at home now crumbles under the weight of real courtroom procedure and evidence. Every attempt to control the narrative fails spectacularly, and it's mesmerizing to watch, because this is exactly why you hire professionals. You don't learn this overnight. The rules of evidence are not suggestions, and the burden of proof is relentless. The more she tries to assert control, the tighter the legal noose becomes. It's like watching someone arm wrestle a hurricane while thinking they're winning. Their strategy is collapsing under logic, facts, and procedure, like a house of cards. And yet we can't look away, because every stumble is a lesson and every confident claim is a cautionary tale. The crash test dummy analogy has never felt more accurate.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines?
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes. And I did. I received that. And apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No.
Closing arguments are next, and this is pure gold, because so far our legal adventure has been a masterclass in what not to do when representing yourself. The defense presents nothing, the evidence is overwhelming, and the strategy appears to be hope and confidence alone, but closing arguments are where reality punches back hard. It's your last chance to explain your position, and instead, we get silence punctuated by misplaced bravado and wild optimism. The courtroom watches the spectacle unfold like a suspense thriller. The state is calm and collected, armed with facts, while our protagonist is armed with nothing more than wishful thinking and misplaced confidence. Every gesture and word screams desperation and inexperience. It's both tragic and comedic at the same time. The audience can only marvel at the audacity and cringe at the consequences. It's the perfect storm of chaos and learning opportunity, and we are all along for the ride.
All right. Do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right. Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
And here comes the part where the strategy really unravels, because our Karen is now focused on the wrong target. She thinks she's fighting the IRS or some shadowy villain instead of the very real consequences of her probation violation. Every word and claim highlights the disconnect between fantasy and reality. The courtroom isn't interested in your personal narratives. It wants facts, it wants evidence, and it wants results, but confidence alone cannot provide any of those things. It's almost fascinating to watch the mental gymnastics unfold as she tries to justify her position while ignoring the very real issues staring her in the face. Meanwhile, the officer and judge remain unflappable, calmly applying the law and procedure as if nothing is unusual except the human comedy playing out in front of them, and the audience can't help but mentally tally the lessons while enjoying the entertainment. This is how fantasy meets reality, and the crash is inevitable.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Now for the fun part. The consequences are about to be counted because time in jail is coming, and the reality of self-representation hits like a ton of bricks. Every minute matters, every decision matters, and yet our Karen seems to believe she can negotiate with fate with confidence and charm alone. It's an expensive lesson measured in hours and dollars. And yes, the audience can't help but chuckle at the absurdity of it all. $1,200 a minute, or however you want to frame it, it's a jaw-dropping spectacle of misunderstanding and miscalculation. This is exactly why professionals exist, because navigating probation, violations, and court procedures is not a game. The more you ignore it, the harder the consequences land, and watching this moment unfold is like watching slow-motion chaos meet perfectly calculated law. It's tragic for her but perfect theater for everyone else, and a cautionary tale no one will forget.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Finally, we reach the end, and the lessons are crystal clear. Having a trained public defender matters more than bravado or self-belief. You can have all the confidence in the world, but when the facts, evidence, and procedure collide with inexperience, the results are predictable. The courtroom has spoken, the law has been applied, and our Karen is learning firsthand that audacity is no substitute for preparation and skill. The video wraps up with a perfect mix of humor, caution, and insight, because the moral is obvious, but delivered with entertainment. Every viewer can nod, laugh, and take away a lesson while enjoying the spectacle. The call to action is gentle but effective, reminding everyone to like, comment, subscribe, and stay tuned for more courtroom chaos lessons. Learn the stage is set, the curtain closes, and we walk away wiser, entertained, and slightly horrified.